Hi, my name is Victoria. I'm one of the estate planning attorneys with the Copenbarger law firm, and today we are joined by Zachary Rayman of Lifestyle Financial Services. And yes, the Raymans are married, so it is my husband and I doing the webinar today. Lifestyle Financial was founded by our founder's wife. So Lloyd Copenbarger started Copenbarger. Laura Copenbarger started Lifestyle Financial. And one of the biggest benefits to having had these two companies and these firms working together for so long is what we've really come to find time and time again is there is so much overlap between estate planning and financial advising. And unfortunately, when you have either an estate planning team or a financial advising team that are unwilling to work together, things get missed. And a lot of times what gets missed can have really big implications, not necessarily for you, but for those of you left after you have passed away. And so what we want to help address is how to make sure you're protected during life and that your finances are working for you, but also once you pass, that legacy you're looking to leave really is captured and fulfilled. One thing I do want to mention is everything in these videos is for educational purposes only. If you have specific questions, please set up a time to speak either with us here at Copenbarger or Zach over at Lifestyle so that we can make sure your specific needs get addressed. As far as Copenbarger goes, if you have not met with us before or it's been a while, we want to make sure you understand we are a full-service estate planning firm. What that means is not only do we help set up the foundation documents and make sure that your intent is captured, we also are there to walk alongside when things go above and beyond the estate planning, whether that be in business and tax or advanced planning and charitable planning, whether that be after somebody has passed away and a trustee or beneficiary needs help, or if we have been unable to avoid court for one reason or another, you need assistance in litigation. We are here again as a full service planning firm to make sure those needs get met. But as attorneys, we absolutely could not do what we do without our incredible staff. So we have one of the largest staffs for an estate planning firm that helps ensure we really can get clients answers as quickly as possible and get things done for them as quickly as possible. We also have offices all over the state. We also meet over Zoom and the phone. Essentially, we are accessible. The same can be said for Lifestyle Financial. Both companies serve the entirety of California, and so if you need us here, we're there to help you. So let's jump into the actual meat of today. We talk a lot at both companies about legacy, because legacy, we know, goes into so many different facets of our lives. Sometimes it's the financial side, the emotional side. It really can depend from family to family. But ultimately, what both of us are here to make sure is whatever that legacy wants to be for you or that you want it to be for your family, that we're helping you accomplish those goals. So first and foremost, when we talk about estate planning, one of the things a lot of people don't do is they will set up a plan and then they never look at it again. With estate planning, life changes can absolutely and often do impact your estate planning. The same can be said for the financial side of it. As you hit different milestones, as your family grows or your assets change, circumstances change, it is imperative that you come in and meet with us to go over what your estate plan needs to do to continue properly providing for you, your loved ones, and again, that legacy once you have passed away. By not updating plans, it can unfortunately cause huge issues. And again, most of the time it's when you're gone and no longer able to advocate what your intention was. And so having a clear plan while you're alive absolutely helps ensure, again, that legacy continues even when you're gone. So when we're talking about trusts and planning, what are we really looking at? One of the big things is how to transfer your assets. We want to ensure that not only do they go where you want them to, but they get there as efficiently and effectively as possible. One of the big things we'll talk about is the fact that your trust has to actually control certain assets. So things like your checking accounts, savings accounts, and non-retirement investment accounts actually get titled in the name of your revocable trust. If this step is missed, it can cause issues once you've passed away. And by having an advisor who knows about that component, it can help with the double check to ensure that the assets really are titled correctly and will pass as you would want. Another big component of planning and legacy has to do with charitable giving. So for some of our clients, they want to do charitable giving from a truly just altruistic side. It has nothing to do with taxes, capital gains. It's that you are interested in either during life or after death, leaving something through your estate plan for a charity. But for some people, it goes even further, where we are considering how to ensure that taxes are minimized and that capital gains are either minimized or in some cases even eliminated. So tax components can absolutely have to do with what planning we're going to do for you. Family memories and heirlooms, things of that nature, are often very much overlooked and missed when it comes to estate planning. That is a crucial component of legacy for many of us, because items often, if a story isn't captured or the generational information is not passed down, it gets lost. And so one of the things at Copenbarger we take seriously is how to make sure that those things are captured as well. And then for some clients, when we're talking legacy, it's about the next generations and ensuring that they have the education you want for them. So that could be for your own children, your grandchildren, great-grandchildren, but setting something up, again, both during life and even after you're gone, to help ensure that they can have the education that either you or their family would want for them. Now, when we talk about estate planning and how to help preserve that legacy, it's not a one-size-fits-all. For every person we talk to, we're going through a series of questions to make sure your plan is comprehensive. Because again, not everybody will have the same goals and not everyone will have the same wishes. But when, again, we're talking estate planning, it's also not one document. We're looking at a comprehensive set of documents to help make sure, whether it's due to incapacity or after you've passed away, that you are in control and the court doesn't get to have a say in what happens with you, your assets, or your family. One or actually two of the ways we do that are with advanced healthcare directives and durable powers of attorney. Healthcare directives are imperative. As soon as you turn 18, no one has an automatic right to make medical decisions on your behalf. And so you need to make sure you have in writing who can do that for you if you have lost the ability to give verbal authorization and consent. So the healthcare directive is an absolute must for someone to have. It also must have been done since 2004. So if you have a directive done pre-2004, it is important to note it is no longer accepted or effective. So if you don't have one, or you have one older than 2004, come in and see us and let's make sure we get something in place that's valid and effective. The durable power of attorney is another one that is imperative. Because again, if you have assets and cannot give authorization any longer, it has to have been done in writing prior to you losing competency so that someone can still manage your money. This, especially, I'm sure Zach can attest, is an extremely vital document, but not all documents are created equal. There are a lot of free things online that people use that don't actually give the full scope of authority that is needed to manage certain accounts or assets. And so not only is it important to have a power of attorney in place so that in the event you're incapacitated, someone has authority, it is extremely important to have one that is detailed. A lot of times you'll see the ones that just say check all so that all of the powers are going to be captured. But a lot of times that's not enough. And a lot of times the powers are not extensive enough to, again, protect the assets you may have. Now, some people will ask, well, I'm married, so why do I need this? Can't my spouse just manage things? In some cases, the answer is yes. But for accounts like your retirement, you are the sole owner of that account. Your spouse has no automatic right to come in and start managing that without your authorization. And again, if you're incapacitated, it needs to be in writing who has that authority. One question on the healthcare was what happened in 2004 for it not to be valid? HIPAA laws. So privacy changed in 2004 for medical, and without a specific HIPAA authorization statement, which did not exist pre-2004, it is no longer valid. So that was a big change that swiped away any done before 2004. The next document may or may not be needed, but it is important to know about in case it is relevant, and that is a psychiatric healthcare directive. This is a directive specifically designated for people who could or are in a psychiatric healthcare facility. So this is not memory care. This, again, is psychiatric care. If you are likely going to need it or you're concerned about would you end up in a psychiatric healthcare facility, it is important you talk to us about this specific directive, because this is the one that a lot of the facilities need in place that goes above and beyond what a normal healthcare directive would do. Now, one of the other reasons those former documents are so important is if you become incapacitated without having those in place. Unfortunately, the only way for someone to be granted authority is by going to court and obtaining what is called a conservatorship, which is often expensive, time-consuming, and stress-inducing for all involved. Because if you are incapacitated and you do not have the capacity to put documents in place, you are very likely also in a very vulnerable position. And having to go to court and have delay in care or have delay in what can be paid for can cause sometimes irreparable damage, but can absolutely cause a harm that otherwise could have been avoided. Now, I mentioned your stuff. So one of the things that Copenbarger has done in our trust is created what is called a letter of instruction power or memorandum power. Essentially, what it does is it says, if you have an item that you want to be designated to someone specifically, you can use a handwritten letter that says what it is, who it goes to, and you just need to sign and date it. That allows you to have much more control over where items go without constantly having to come and see your attorney. But it is important that it be in your handwriting. And if you type it, that you either have a witness or a notary to help verify it really was you who typed it. But as I mentioned, a lot of times the stuff is overlooked, but a lot of times the stuff is what causes fights and emotional responses after someone is passed. And so designating items can help cut out that feeling component that's on the negative side of it, and it can help capture legacy. Now, one of the big questions we receive is from especially newer clients is, do I need a will or do I need a trust? Most of our clients do fall under the trust category. But for those of you who do not own property, so you don't own any real estate and or have less than $200 and about $9,000, a will may be enough for you. But if you have property or more than that $200 and again, roughly $9,000, a will is not going to keep your estate out of probate when you pass. And so if one of the goals you have is making sure that the estate never goes to court, we need to then talk about doing a trust. So trusts are essentially there to lay everything out while you're able to, so that when you pass away or when you become incapacitated, the terms are already set. This helps protect you. This helps protect any beneficiaries. It helps protect the assets, and it often helps protect the peace of family. And by that, I mean, when things are not laid out ahead of time, peace gets shattered because people don't know what to do if you're not here to communicate it any further. So your trust is designed to preserve that peace. And by peace, again, peace of mind. So your job as what's called the settlor or creator is to set the terms. You get to decide who will manage when you no longer can, who gets to inherit and when, because just because they're a beneficiary doesn't necessarily mean you want them to receive their whole amount at one time, or for them to receive it before a certain age, or to be able to manage it at all. And so there's different ways and things you can do to protect beneficiaries, even if you do want to leave them something, but not necessarily give them full control all at once. Now, one of the other questions we get is, do I need a revocable trust or an irrevocable trust? Most of our clients fall under the revocable trust category because it is a trust that can be changed and revoked, and it keeps the control with the client. Irrevocable trusts are used less often, but absolutely can have a vital component of preserving legacy. For people concerned about the size of their estate, irrevocable trust can play an imperative part in ensuring that their estate is not eaten by taxes after they have passed away. or eaten by capital gains in the event an asset is going to be sold. But the downside of irrevocable trust is, in almost all cases, you're giving up pretty much full control of the assets, which a lot of people don't want to do unless absolutely necessary. But if you do have an estate that is of more significant size, irrevocable trust planning may absolutely play a part in what your legacy planning is going to look like. Now, with revocable trusts, I mentioned that with the irrevocable, people do them for tax reasons. With revocable trusts, you may still be able to do planning that involves tax protection. So one of the things that is important to note with revocable planning is we're going to talk to you about helping preserve property taxes after you've passed away, to help potentially with lowering estate taxes if that is a concern, to talk about the advantages or disadvantages of somebody inheriting from a capital gains tax purpose. So while the irrevocable trust is created a lot of times for the specific purpose of tax planning, your revocable trust allows you to put terms in it that can still have tax advantages without losing the control piece. So if we're asking you what's the value of your property or what your taxes are, things of that nature, know that it's because we're trying to see what can be built into your trust to preserve either what you pay to ensure that your estate doesn't pay an unnecessary tax, or at a minimum to reduce unnecessary taxes. But I mentioned at the beginning, one of the issues with trusts is that they need assets to actually be titled in the name of that trust, which again is where working with an advisor who understands that can be an imperative component of the solution. However, we know that things happen. Sometimes people open new accounts and they forget to put something in the trust. They forget to tell their advisor they have a trust. They buy a new property and the title companies don't ask if someone has a trust. Things happen where after somebody dies, their assets are not correctly titled. So what Copenbarger has done is created what is called a pour-over will. What this will's job is to do is to ensure that the court doesn't get to control where an asset goes, even if it was improperly titled. That instead, the asset will still ultimately go back into your trust and be distributed how you had set up initially. So it's not a perfect solution, but it is absolutely a safety net to ensure your wishes are the ones that are carried out. So again, when we're talking revocable trusts, we're really trying to ensure that the family harmony is preserved, that your legacy is preserved, that your intentions are preserved. Because once you have lost capacity, once you have passed away, often these documents are the things that continue speaking on your behalf, which also is why it is so imperative to make sure that they are kept up to date. You don't want your documents speaking from 30 years ago when you didn't have children. If now you have kids, grandkids, you have multiple properties, and the landscape looks completely different. That trust from 30 years ago isn't speaking for who you are today. And so while we build in contingencies and different things to account for life changes, they don't cover everything. And so what we recommend is that our clients come in every 3 to 5 years to speak with us to make sure, has life changed or has the law changed in a way that your trust then needs to change or your healthcare directive needs to be updated. Because again, if you can't communicate, these documents are doing it for you. And we want them to be as close to perfect and as close to your intent as we can absolutely get them. Now, one of the things I also mentioned is charitable planning. So some people want to plan during their life. They want to see their gifts come to fruition while they're alive. Some people want to leave something once they've passed away to continue that giving even when they're no longer here. Now, some people don't want any charitable giving tied into their trust. They want it somehow done during their financial plan. But with the trust and with your estate planning, it is a vital component of many of our clients' planning, whether it's a one-time gift, again, when you've passed, or as I mentioned, you want to see it come to fruition during your life. Now, one of the things I do want to emphasize with Copenbarger is while, yes, in a lot of our educational videos, we talk about revocable planning, We do extensive planning above and beyond that in the form of advanced planning. So if you have a situation that may be more specialized, if you have something that's a little bit more finessed, still come and speak to us about it, because the odds are we can help you get the planning you need set up. Now, I mentioned 3 to 5 years, that every 3 to 5 you should come in and see us. And the reason is, again, things change. One of the issues we often see is people assume that changes are simple. And by that, I mean, oh, I'm just changing somebody from trustee 1 to trustee 3. I'm going to start deleting people and writing names in. When you start to write all over your documents, you can actually invalidate them. You can cause confusion when you pass away. You can cause court involvement to become a necessity, because when you start to write on things, again, it leads to confusion. So if you have updates, please contact us before you start writing all over the documents. There are certain things you can absolutely do without our involvement, and we want to make sure that you have the ability and awareness to do them. But there are definitely, and most things, that need to be done with a formal amendment and with the attorney. Because again, when we see clients who've started writing all over their documents, or they're doing a handwritten amendment, there's often a step that has been missed and can either invalidate the change, or, as I mentioned, invalidate the full document. So it is always better, and frankly, in the long run, cheaper, to ask up front than to guess and hope you're right, but ultimately end up wrong. So again, come and speak to us. One of the things I did not mention yet is, by watching this video, you do get a free consultation with Copenbarger and with Lifestyle if you would like one. So if you do have questions on your documents and you are concerned about, is a change able to be made at home or with us, take advantage of that consultation and come in and speak with us. So let's go back to some charitable planning. So I mentioned for some of our clients, they want to see the charitable giving during their life. But for some people, they're also concerned about, my estate has hit a certain size, and I'm interested in charitable giving to help minimize capital gains or tax consequences. Charitable trusts are the way that we are able to do that. So I talked about revocable planning. I talked a little bit about irrevocable. This is called a charitable trust. And so essentially what you're able to do is put an asset into this trust, a lot of times still retain some benefit from that asset, but also keep a benefit of minimizing tax implications down the line. So it's a little bit of the best of both worlds. We're keeping money in your pocket, or frankly, out of the government's pocket, and you're doing something to help benefit an organization that, assuming it's something you really like, is then doing something in the world that you would want to support. So it really can have a best of both worlds scenario. As I mentioned, it allows for the now giving. It also then allows for the after you've passed away giving. So again, for some people, they're wanting the legacy to continue even after they are gone. And so if charitable giving is something that you are interested in, we can definitely talk about what charitable trust is right for you. Again, one of the things we're looking to avoid is court interference. And so after you have passed, one of the ways we're trying to avoid it is by having the beneficiary designations clear, so that things can roll to who you want or what you want without the court having to get involved. But there are a lot of types of charitable giving trust options. And so again, it's not a one size fits all. So one of the things our advanced planning department does is walks you through, based on what your goals are, which of these vehicles is going to be best and right for you. So if you have any questions on any of that, you can definitely come and speak with us. One of the questions that just came in is, what sum of money is needed to think about charitable giving to reduce capital gains? When it's reducing capital gains, it's not necessarily the sum of money, but it's what is the asset and are you looking to sell it? And if you're looking to sell it, what did you buy it for versus now what are you selling it for? So that will be property, that can be stocks. It's anything that if you sold it has some kind of a tax liability from the start to the finish. So that's not a clear, there's a certain amount of money. It's more, what are the tax possible ramifications and are we able to avoid those? So if you have any further questions or if you have an asset you're concerned about, we can then address that more in depth. I am now going to turn it over to Zachary Rayman of Lifestyle Financial. As I mentioned, Lifestyle was founded in 1995 by Laura Copenbarger. So Lifestyle, after Laura retired, was handed over to her grandson, Charles Sosa, who a few years, well, actually about 4 or 5 years ago now, brought Zachary on out of Merrill Lynch. And again, one of the great things is working with a company who understands trust planning and the symbiosis between the companies. With that, I'm going to hand it over.
Thank you, Victoria. Hello, everybody. Thank you so much for taking a little bit out of your day to hear us speak. Our thanks at Lifestyle to a wonderful 3 decades and counting relationship with Copenbarger Law Firm, obviously founded by a husband and wife who are very interested and motivated in protecting families and already building this legacy on the ground floor for preserving assets and wealth, however it may be defined, because it's not the same for anyone or anyone's situation, from one family to the next for the years and decades to come. So a little bit about Lifestyle Financial. We have been around since 1995. We have uh, several advisors. Myself, I came from a small firm called Merrill Lynch. I was part of their high net worth wealth management and planning department. It's a very large department, but suffice to say that that just taught me a lot about the behind the scenes and the back ends of financial planning. And I noticed very quickly the importance of understanding and cooperating with the estate planning and trust attorneys, such as the great attorneys at Copenbarger estate planning firm, for the benefit of every situation. There is a very high level of value that one mind can give you in this process from the financial planning or the estate planning side. But the best way to do it is through the power of cooperation by committee. And so some of the questions that might come up, there will be a answer, maybe a partial or full answer from Victoria, but maybe there's something that I can also add to or a different lens of thinking. And although Lifestyle Financial does not provide tax advice, in the financial world, that is not a good excuse to not be tax aware. So a lot of what we're going to be talking about to maximize charitable tax strategies is in fact understanding what buckets or what strategies are appropriate for you given your situation. And as we'll talk about a little bit later, the changing landscape is getting quicker and quicker in the rate of change. So it's even more important to have your team up to date on all these changes as they get implemented. We want to make sure that nobody gets confused. So I often will repeat myself or try not to use any big words or speak too quickly because understanding is very important here so that we can have an in-depth conversation because financial planning, especially in your estate planning, is a very hands-on process in the beginning so that you set everything up well for us to then implement these plans. Because the question that I'll always ask people is, what is the next 50 years going to look like? I can tell you, we will not be the same today that we are in 50 years. So you want that plan to be able to move fluidly and be updated or refined or constantly referred to with very good, credible guidelines and rules for those next 50 years and changed when appropriate. As I said, we have been around since 1995. The way that I like to summarize this slide is if you are concerned about something that is worth more than $5, we generally can talk about it, even if it's $4.95 after adjusting for inflation. Our role is to dissect or take a look at everything, go under the hood of what that investment is, whether it be real property or an intangible asset or a tangible asset like a stock or a bond. We pride ourselves on looking at everything in a holistic process so that we can best then translate what we're looking at, make sure it's what you see as well, and then figure out the right plan and then relate it all back into the estate planning that you go through great work to build out. So a few things that you need to know about in your investment picture within your estate plan. Diversification, planning, education. These are tools in the financial toolkit to help you understand what type of investment and then strategy is important for your estate plan. Not just in the present, but say you're going to retire in a couple of years, planning for that retirement date. We call them life events. If you have a child or a grandchild and you want to help them get to college, or you want to help them get started in life, or if you have a big dream or goal or project you want to build, there's usually more than one way to plan and invest to accomplish that goal. A few other things that we like to bring up front about is having all your eggs in one basket. There is no such thing as one thing works forever, nor is there something that nothing should be overlooked. Every stone should be turned over and looked and thoroughly examined. Real estate has its place in a portfolio. Talking about, we're out here in California, there's a lot of technology companies. You have to understand financial companies, energy companies, infrastructure, and real estate companies that are investable assets. Where do they go? Do they go in a IRA account? Are they in part of your 401k options? Do you put them in a brokerage account? Understanding the right pieces build the entire picture, and then we dive into this. So part of our planning education process is we want to be available. Everybody who's been in attendance here, as Victoria said, gets a free follow-up conversation with either myself or Charles Sosa or anyone in the lifestyle team or both of us. We are here to make sure that we are the right fit because we may be giving you really sound advice, but we also want to make sure that we're communicating in a way that resonates with you. That there is more than one way to say a word. There's more than one way to say a stock or an equity. We want to make sure that we are matching the right vocabulary to everyone. And this landscape changes. We're going to go in right now about a couple of changes that just happened this year, because that is very important for all these sort of baskets of investments. To start, we look about certain type of retirement assets. Earlier this year, the current administration and Congress passed what's called the One Big Beautiful Bill Act that sizably changed both the tax, estate, and financial planning components for any household. And so what we want to look at is what areas of investment are now being maximized or are underinvested in that make the complete picture for you. For example, there are upped limits if you are in the present wanting to make a charitable gift to, say, a family member. You can pick a higher threshold for 529 college education funds, which can be set up. Say you have a grandchild on the way, you can set them up before they are even born. Or if you have a young grandchild or a child or a niece or a nephew, you can set up these investment accounts and fund them up to a certain limit this year, or you can front load it all within the provisions allowed in the One Big Beautiful Bill Act that are exempt from the estate tax deduction. And we'll walk you through that. If you want to set up a minors account for children, there are several different type of minors accounts in the state of California. It'd be for a child under the age of 18, where you would keep control of that account. And then you would want to have your financial advisory team, along with your estate planning team, educate the situation or help give guidance so that when someone reaches the age where they are supposed to be in control or have access to these funds, they are able to have the knowledge to make the most prudent or good decisions with these funds that you have been able to transfer to them over the years. We also want to talk about different strategies. If, say, you are working and your spouse is not working, there are spousal IRA contribution rules that you can take advantage of that can help add to the retirement asset planning part of your portfolio. This is not just a one-time situation. This is an annual transfer of wealth that you can take, and in certain situations, you can deduct from the top of your income so that your taxable return each year is less. Non-retirement assets, most commonly called a brokerage account, which would be the primary account that you would want in your trust, because this is not a 401k or an IRA or 403B or 457 plan, any sort of group retirement plan or individual retirement plan, this sort of account is a taxable account. A taxable account or a non-retirement account may very well end up being the most important account because you get to use these funds in your lifetime without any early penalties. And though you have to be aware of the taxes that come with buying and selling, or taking money out or transferring money, there are also many additional tools that you can use for more complex financial planning, such as borrowing tax-free from yourself if you are trying to fund a project in the short term. You then layer all of this in the different sectors of investing. There are more funds or exchange traded funds, also called ETFs, mutual funds, than there are publicly traded stocks. They're basically overlapping each other as the industry in the financial world tries to get more and more ways of investing dollars out of a bank account and into something in the markets. What we try to do is simplify this. You don't need too many, you don't need too few. There's just a right number, and we try to match the appropriate number to what you are planning for. As an example of how all this is impacted in the present, the One Big Beautiful Bill Act sizably changed how an estate may give charitable gifting, especially for higher income earners in states where there's a higher income tax, and then everybody on the federal tax level. Now, this is a case-by-case situation, so this may not apply to you, but this is a great and timely update. The founder of the company Dell, Michael Dell, and his wife made a $6 billion charitable donation to fund the Trump child accounts, which, because the One Big Beautiful Bill Act, will be able to impact over 130,000 children starting in January of next year. That is a one outsized picture, but you can take that as a case study, and we can then understand how that relates to your specific situation. And that's a big part of what we do in trying to help your financial plan work most effectively in your estate plan. The other thing that we hear a lot is in the retirement asset world, what type of retirement account are you trying to end up with, or are you trying to grow? Such as a tax-deferred account, which would be a traditional IRA, or an after-tax account, such as a Roth IRA. And then the mechanism or the way in which you take money from one bucket, the tax-deferred bucket, or the traditional IRA, into the Roth IRA. And there's multiple ways to do this. And based off of your specific situation, what makes the most effective sense in your estate plan, we then implement that strategy over the years. This is not just something that you do one day to the next. It's something that's supposed to be over a life cycle, because investing at the end of the day stays with you through retirement, stays with you well into retirement, and in many situations for generations to come. A couple of the other things that we want to discuss and the takeaway that you want to have is, if you're trying to leave a legacy and there's some sort of charity that you want to gift, the strategies that we try to implement in your financial planning make sure that the gifting well exceeds the initial amount that you want to give. If you want to fund an account that's in your estate plan, our job is then to grow that account so you can give more gifting, whether it be in your lifetime or after your time. That is all part of the planning process. And then we also look at what the tax advantage will be given the current landscape. You blend all of that together, and that's the essential importance of the financial plan in your estate plan. We also want to pay special attention if there are certain estates that are over the current estate tax limit, whether it be as an individual or for a couple. There will be multiple appropriate strategies factoring in real estate or intangible assets or illiquid assets, and then stocks and bonds and cash or tangible assets. They provide a perfect balance where you want to look at everything on this balance sheet and then figure out what bucket to pull over your lifetime and how to fund things for years to come. There's not any one size fits all investment strategy, which is why we like to repeat and hone in on the fact that your specific plan will be built for your estate. And then we rely on the documentation or what's in the four walls of your estate plan documents to make sure that your financial plan is working as efficiently as possible. A big thing that we've also encompassed is that as people are living longer and the cost of living is coming up and people want to help families for extended periods of time, we have to factor in what kind of investment vehicle do you want to use, whether you want a pure growth strategy, a growth and income strategy, or an income strategy. Now, maybe you have given this considerable thought, and that's great. We encourage that. And we'll give you resources to continue thinking about it. But then we want to be the sounding board to make sure that the thoughts that you're thinking about inside your mind are actually being implemented day to day and for years to come. That is the essential practice of taking the idea and implementing it into reality. So at this point in time, you ask, well, what do you do with all this information? Or this is a great starting block. I want to refine this process. I want to dive deeper into what changes the One Big Beautiful Bill Act, the One Big Beautiful Bill Act did. How does it change anything from Secure 2.0? Because this constant landscape is changing so quickly. Have a meeting with us. We'll take a look at your specific situation and best advise you on where to go from there. There are going to be probably more questions than answers after the first meeting, but that's why we want to make sure that we are available and that at a very minimum, we're refining or targeting your thought process that it aligns more complete with your estate plan. Because again, it's going to be different than somebody else. And so the importance is making sure that you're taking care of 100% or 360 degrees of your particular financial plan in your estate plan. We do want to reinforce just how close we work with the estate planners at Copenbarger and Copenbarger. I cannot emphasize enough, as Victoria mentioned in the beginning, that a lot of times one area that touches wealth, whether it be the financial planner or the estate planner or the tax planner, tries to do everything. We are very well trained to complement each other, and that enhances the return or provides a better service to what you need. And so we work hand in hand. There's many rules that are in place on the estate planning side that then translate over pretty neatly into the financial planning landscape. We talk about documenting and titling all the time in bank accounts and investment accounts outside of your retirement accounts. Very often, a husband might just have an individual name account. You went through all this work to get an estate plan. You have a wonderful revocable living trust, and then you don't go to the bank and update the titling on those bank accounts or on those CDs, which are in a savings account, which the checking account does not cover. Or you have one investment account at this firm, and then you have a smaller investment account at another firm, and it goes on and on and on. Or maybe you have all of your brokerage accounts covered in your statement, but you forgot about your insurance policies. We cover all of that as part of the financial due diligence in the financial plan that goes into your estate plan. Again, they work hand in hand together to best help every individual situation. And just as Victoria said, whether it be call or in person or Zoom, we are able to see you all across the state of California. Our firm is licensed in every state of the union. So if you move, we can move with you. We do that frequently. And we look forward to hearing every situation as they are unique and then figuring out the best path forward for your overall financial health and well-being. As a close, please keep in mind, and this might be very common to everyone, investments have inherent risks. We will educate you on these risks well beforehand. Every single day brings a new element to the financial landscape that includes real estate or stocks or bonds or even cash nowadays or alternative investments. The landscape is growing. It's changing faster and faster. And at Lifestyle Financial, we encourage people to not be shielded from all this information. We want to be a center of this information, and we tend to look into all this because it's going to impact your financial well-being. So you want your financial team to be looking at all these areas to come up with the best plan and then list of recommended solutions on a case-by-case basis. And then we do not give the tax and legal advice. We work hand in hand with your estate planning professional to make sure that everything goes back to that estate plan that is so vital in this landscape to best protect you and your affairs, whatever the plan may be, giving to a charity, giving to multiple charities, taking care of your spouse, taking care of your family, proper succession of a business. All of that has a financial planning component, and then we will lay it back into the estate plan. Thank you guys so much for this time. I'm going to bring Victoria back in here, and I look forward to hearing from you all.
All right, thank you, Zach. Let me just double check. We had one question for you if you have a moment. So, question was, what specifically did the big beautiful bill do to decrease taxable income? Is all charitable giving affected? Before it was X of your income is deductible and anything above was lost is not deductible. Do you understand all of that?
Yes, these are great questions. We can dive into it, schedule a meeting with me, especially that third one. I'm going to need to see or I'm going to take it piece by piece. There are three question components. I think the first one was what specifically
What did
happened
it
to the
do to
one.
decrease taxable income?
Yeah, so very broadly, because what the one big beautiful bill did is it made permanent certain temporary changes that the 2017 Tax Cuts and Jobs Act did, such as doubling the estate tax exemption and doubling the standard deduction. Those were temporary, meant to sunset or go away at the end of this year, 2025. The one big beautiful bill made those permanent. The other thing that it did for most incomes in America is it increased the standard deduction from $10,000 to $40,000. This is huge because the complexities and times for itemizing deductions did still net out for many people that it would be better to go through that route than just taking the double standard deduction. This $40,000 limit, subject to certain income returns, so there's a threshold for individual filers or joint filers, it phases out. But for most people, this just netted you an additional $30,000 in taxable income that just gets wiped away for income tax return purposes on the state, where it's state appropriate, and the federal level, most importantly, because the federal level is where every state has to worry about this. That was the first one. What was the second one?
Oh, is all charitable giving affected?
It depends on the size. There was a question earlier about how much do you need for charitable giving. This overlaps with that a little bit. It depends on the size and it depends on the vehicle the charitable giving is being given away to, whether it be cash or stock or real estate. That's a case by case situation. And so unfortunately the answer is it depends. Have a meeting and we'll dive in and we can do a little bit more research and I can give a more direct recommendation. Um,
That
Third
tied
one.
into the last piece, which was
Yeah.
about income being
Yeah.
deductible and anything
Yeah.
above.
By and large, this mostly impacted the top brackets. There's this now, there's uh, the shorthand would be, I would call it the adjusted gross income, or they have another acronym for it. It really impacted the top earners for federal tax purposes, and it did take, depending on how charitable you want to be in any one given year, it did take a pretty good haircut. Now, having said that, the tax benefits are actually preserved if there are certain investment vehicles you use to get the lifetime tax deduction gift benefit, but you have to structure it right with your financial plan, what vehicle you want to invest in, and then make sure it's very clearly outlined in your estate plan. Because what they basically did is they made it less financially suitable for certain people on the top level to give as much as they were giving if they wanted to give for tax deduction purposes. Or say you have a huge IRA and you wanted to bypass income tax from IRA required minimum distributions. We can look at that on a case by case basis and give you much better answers, but that's the 30,000 foot view.
Perfect. That was it on questions. Thank you so much.
Yeah.
And thank you all for attending today. Again, one of the big things we want to make sure is what are your goals? Where are you at today? Where are you looking to get to? What are you looking to leave for your family or charity or friends? What is that legacy looking like for you? And so, again, that is where having a team of professionals involved can really make a huge and vital difference. One of the things in the chat that you will see is a survey. We absolutely want to know, how did we do today? Did these topics hit what you were interested in learning? Did we address things as much or as little as you would have wanted? Because all of our education videos are designed to help you. We want to, again, make sure that when you're working with us, whether that's in a direct appointment, whether it's on these webinars or videos, that the issues that our clients are having or the questions that are coming up truly are being addressed. As I mentioned, for both Lifestyle and Copenbarger, as a result of attending today, you are entitled to a complimentary consultation if you have not already taken advantage of that for the year. Obviously, the year is coming to a close, but it does not expire at the end of 25. So if you come and see us in 26, we are more than happy to meet with you then. With that being said, I hope everybody has a wonderful rest of the day, a wonderful rest of the year, and we look forward to working with you soon. Thank you so much.